All right.
Yeah, it's here right there.
Where's our third judge? No. Okay, you can be seated. Thank you.
Please move forward, because I still can't really see you. There you go.
Take your hobby out. I think it was the back.
Who's recording?
Gabriel and in representation for Clinton State, Correctional Facility, and Commissioner of the Shooting Correctional Facility, Mr. Manning. I look forward to provide specific arguments which will demonstrate that the lower court did not err in their ruling. In turn, we will argue that Mr. Andy Potter's religious demands are associated with a high compelling government interest. Also, we will argue that Mrs. Holly Potter's allegations are considered intentional infliction of emotional distress or publicly stated information on this motion of reckless disregard. We also will provide arguments of why her acts are considered in the religion as based on this information, the acts of the ruling of the lower court is improper.
bathe, asking him to bathe, that's also a part of his religion, to bathe only once a month. And asking him to bathe once a week instead of bathing once a month is also limiting his expression. And I think that that's totally against the First Amendment of the United States. And the Swindon Correctional Facility could have used the least restrictive means by telling him when he steps outside of the cell, he must bathe. When he's inside his cell, he decides not to bathe.
What you're really suggesting then is that they confine him to the cell and allow him to dress the way he wants to dress, and bathe the way he wants to bathe, and repair the way he wants to be, and the moment he does that, then he has to stay in his cell.
Yes.
So he would be leaving his cell once a month only.
Yes, sir.
He would be doing and that essentially be in voluntary confinement.
Yes, sir. I think that's the only way to allow him to practice his religion freely. Yes, sir.
You go by the act below.
I don't think the lower court actually ever tackled the issue, but I'm pretty sure it was raised in
Well, this is my way to interject that we have a limited fact patterns, and so, you know, there are some.
Warren Holly is standing outside the prison, violates her constitutional rights of freedom of assembly under the First Amendment. The Constitution clearly states Congress shall make no law respecting the establishment of a religion or prohibiting the free exercise thereof. Abridging the freedom of speech or she's assembling herself who cares to join her. She hasn't formed her assembled yet, but the people of her naturalist religion will try to assemble with her. Are more than welcome to do so. Not only was she assembled peacefully, she was also expressing her right to be restful with the grievance. By taking away her right to stand outside and taking away her right to address, but giving her a chance to speak what she has to say to him directly, which she also has a right to do.
She had been used to communicate with him, so it was only the person's self-care. Why did you?
It was also to express her distaste and dissatisfaction with the treatment within the whole bars and the way the prison was being carried on. And in order for her to, I guess, fully get her outreach of what she had to say, she felt the best need to protest upon public grounds for the project. Okay. The Constitution Amendment also states that place chosen by a group of people to exercise their constitutional rights peaceably to assemble for redress of grievances must be public or a place to which the public customarily has access. Must also be a place that resembles a public thoroughfare. She was standing outside. She was sitting outside in the parking lot, which is common grounds to any public person who comes in the grounds of the prison. Her standing outside with respect to the Constitution, her being denied that in the form of denying her human rights, political freedom, and civil liberty to protest it. There is no reason for her to be barred from these grounds as no crime has been committed. She hadn't stood there committing any crime, she's just standing there within itself.
Criminal acts require
Well, that's what I'm insisting. I'm insisting in regards to removing her from the ground. It would be more of, I guess, public interest should there have been criminal action occurring on the scene. Her just standing there and deciding how she feels, expressing her feelings within the situation. She's not harming anybody. She's not, she poses no imminent threat to Colin, to the inmates, to the employees. So therefore, I don't understand. To me, it seems as though it's a preferred interest, not a compelling governmental interest. And the preferred interest would be that of Molding, because she's not harming anyone else. really like certain situations. I also feel that the trial court erred in holding that the Partridges were guilty of invasion of privacy due to the public nature of the information supplied. Invasion of privacy requires the disclosure of private facts. The key word is private facts. The publishing or widespread dissemination of little-known private facts that are non-newsworthy, not part of public records, public proceedings, and not of public interest would be offensive to a reasonable person if made public. Holly Partridge can't be guilty of invasion of privacy due to the fact that disclosed information wasn't considered to be private. Well, the invasion of privacy, I think the invasion of privacy that we have in the information fact, the information fact pattern was that of pictures of his home, his automobile, and his family. All those pictures can be obtained in multiple places. I can go online and Google the school and get the whole front post of what's standing outside right now. All you need is you're right, but within the pictures, there was no present, the family wasn't present within those pictures. It was just a home. In the information fact pattern, we state there was anyone present in the pictures that were taken when the pictures of the home were taken. It was just a home. Yes, they're separate pictures, but they're not, I guess you say it wouldn't be a lot of just one solid picture. It's his home, his family, and the audience. According to the reinstatement of torts, section 652D, publicity given to private life. There is no liability when the defendant merely gives further publicity to information about the plaintiff that is already public. Thus, there is no liability for giving publicity to facts about the plaintiff's rights that are matters of public record. There is no liability for giving further publicity to what the plaintiff himself leaves open to the public eye. He cannot complain when his photograph is taken while he is walking down the public street and he is published in the defendant's newspaper. So basically, in the fact pattern, it wasn't stated how the pictures were obtained, where they were obtained from. So it kind of leaves it to be a vague situation. There's no exact instance where they say how she obtained those pictures. Therefore, it really can't be pinpointed where the invasion of privacy took place if the pictures in fact were taken within public grounds on a public street. In the case of Bailey versus Hunter, Arrows Press Inc., 614-969. Both Navajo Indians sued publishers and a museum for invasion of privacy based on pictures that were taken while they were on their reservation. The pictures were used in a magazine article later on depicting the mother of one of the Indian mothers and her child. She was carrying around her child. The release of the publication was felt to be an invasion of privacy in regards to the Indians. They felt that it was, their private life and it should not have been published without their permission, without their consent. The court granted summary judgment on the claim that for publishers, on that claim for publishers, because even assuming that the photograph of plaintiff and her infant son in their reservation home was private, it was not so highly offensive as to incur tort liability.
Also, so you're saying is it okay for Mrs. Holly Partridge to post on a website that Mr. Mullen is a rapist, is a pornographer, and a deviant? You're saying that is correct?
I'm saying with regards to her rights of freedom of speech, as she is allowed to, with her rights of speech.
Were there
the native people, that's all that I have on that one. I also have another case regarding Christmas home. In the case of Hubert versus Crowley, Home Signal Inc., 375, 2B 1386, I believe. Homeowners brought a suit against the Yeah, I do, I think. Yeah, I have 1967. Homeowners brought suit against the newspaper publisher to recover for an alleged invasion of privacy, resulting from the newspaper publication of a photograph depicting the plaintiff's home. The photograph was taken in a public street. It was discussed at the court order that there is no liability for giving further publicity to what the plaintiff himself leaves open to the public eye, insinuating that the pictures were taken in a public street within a distance from his home. His house was just there. I mean, if
How did the plaintiff not be
if you feel that much need for it, if you feel that much need for the protection of your privacy, yes, it's very, people have been to scope when they don't want people looking into their house and into their yards. It's very possible it's not done.
Allowing many parties to religious body, like all other religions that are practiced by current
question that I think you have.
One thing, what is it you keep on citing the religious land use? What is the congressional purpose of religious land use act?
To protect inmates for its
My understanding is the religious land use act was to protect properties of religious organizations from interference in their use by government action, such as zoning ordinances, and things of that nature.
land use and institutionalized persons act. There might have been just a half question relying on vague high priority. That's the only connection that as described in John C. Carter versus Regional Wilkes, state prison officials in 3 separate actions allege that each prisoner was denied rights to practice his religion due to unwarranted concerns about security in violation of land use and institutionalized persons act. Section of RLUIPA increased the level of protection of prisoners and other incarcerated persons' religious rights did not violate establishment laws. The section had a legitimate purpose of alleviating exceptional governmental created burdens on private religious exercise. Did not by allowing substantial burdens to open inmates, but is exercise in furtherance of competitive governmental interests. Elevated accommodation of religious observances over constitutional needs to maintain order and safety did not differentiate among bona fide faiths.
You said something you as that implies that spiritual view is
Not at all. Not at all.
What is wrong with their saying there's security?
There's definitely security concerns, but to our knowledge, one security concern would be in accommodating to a certain extent.
So I'm going to bring back the same question that I asked. That
An excerpt states the following: this court has long recognized that government may accommodate practices without violating the establishment laws. Section 3 of the RLUIPA covers state-run institutions, mental hospitals, prisons, and the like in which the government exerts a degree of control on unparalleled incidents in society and severely disabled to private religious exercise. RLUIPA has thus protects institutionalized persons who are able to freely attend to their religious needs and are therefore dependent on the government's permission and accommodation for exercising for their religious needs. Did the court urge, the district court urged holding that Partridge invaded Colin Moot's privacy, inflicted emotional distress, granted the injunction that the website be taken down and barring Holly Partridge from standing outside the prison property. The First Amendment to the United States Constitution prevents the person on freedom of speech or interfering with the right to speak itself. As presented in the First Amendment to the United States Constitution, shall make no laws respecting the establishment of religion.
go back to the United States earlier, on all the speech and about comparing speech that she made as being
Holly Partridge was standing on school property.
because I hear the right thing, the greatest, when I was her, I did.
She didn't expressly state to a third party. She was on public property, stating she believes freedom of speech.
How did she say?
I believe she was one of 2 parts. considering proving that her ministry should not be in the water. She's on public property.
Thank you very much. Appreciate it.
Sure.
Okay, so, we have that.
Intentional infliction of emotional distress standard as presented in Told before. As demonstrated in Told versus Told, the party claiming intentional infliction of emotional distress must prove 1. The person acted intentionally or recklessly. 2. The person's conduct was extreme and outrageous. 3. The outrageous conduct caused the complainant's emotional distress. 4. The emotional distress was severe. Before a question is submitted to a jury on intentional infliction of emotional distress, the court must determine the person's law. But the plaintiff has presented evidence which, if believed, meets the legal standard for extreme and outrageous conduct. Intentional infliction of emotional distress requires either that the actor intends to cause severe emotional distress or severe emotional distress with a primary risk created by the actor for this conduct.
Is that the end of your argument? There's no difficulty in saying that right now. You're also arguing? You can make it work.
After the argument.
Separate from the argument.
Okay, all right, I just want to be sure, because I know.
I just want to make
Okay.
2 minute comment. Good evening, Your Honor. My name is Daisy Burgos. As for the old law that you're stating, the Religious Land Use Institutionalized Persons Act was done September 2000, signed by former President Bill Clinton. So it is good law. In October, it also asserts that the right of prisoners to practice their religion and restricts prison authorities from denying them whatever items they may reasonably need to do so. On October 2004, the Supreme Court agreed to the rule on the constitutionality of the law and rendered a decision in September 2005. So it is the law.
That's our proposal.
Yes. Yes.
That's my case.
No, yes. And as far as Holly Partridge being protected by the freedom of speech, you are correct, Your Honor, in saying that the website is incorrect. She did violate by saying that he's a rapist without having evidence behind that she knew Moot was a rapist. But what we would like the lower court determined that both parties were right.
Okay, sounds very much.
Okay, so that's why I need to tell you that it's new law.
Good evening, Your Honor. Briefly before, my name is Alvaro Tavera, representation of the state, the correctional facility, and the department. In the intention of improving the quick approach of the issue presented, the first issue I would like to refer to is the correctional facility's policy that prohibit Andy Carter's man of practicing his religion without considering the correctional facility's interest in providing him and the rest of the people in the facility with accurate security means. A pending claim is brought under the First and 14th Amendment. The real intention of the Religious Land Institutionalized Act law is that the inmate seeking relief must prove that the prison policy substantially burdens our religious exercise. To meet this burden, the plaintiff must first show that the burden activity is a religious exercise. Second, that the burden is yes, it is part. The issue here is that it goes for a compelling governmental interest, which the correctional facility cannot allow, cannot put at risk the entire facility's security just for one inmate. Okay, continuing. If the plaintiff satisfies the threshold requirements, the burden then shifts to the defendants to demonstrate that the challenge policies are the least restrictive means of furthering a compelling governmental interest. In making this determination, as cited by Verano Whiskey versus Hart, Fifth Circuit case 2007, the court will give due difference to experience and expertise of prison and jail administrators in establishing necessary regulations and procedures to maintain good order, security, and discipline consistent with consideration of cost and limited resources.
What's that difference if given to the correctional officers is abused in a way, whereas to the law?
In this case, it's the whole reason why we have the court system to determine what's right and what's wrong. Okay, no problem. For our case, it's not the issue right now. I don't see that's the issue of our case, where we're standing by precedent by older cases that the court has ruled upon, stating that this is law. Andy Parcher's primary contention here is towards the practice of his religion, where he demands to be allowed long hair and beard, wear hemp clothes, serve his religious meal, and be allowed to raise only one son. Towards his first hair claim, I would like to rely on the court's judgment on several cases that present almost identical facts. If the court may deem enough and sufficient, the first case I would like to cite is Iron Thunder Horse versus Bill Pierce, a case decided February 9, 2010 on the Court of Appeal for the Fifth Circuit. The Court of this appeal, the Thunder Horse case, was where the Thunder Horse claimed that his rights under the First Amendment and also under the Institutionalized Act law and Arluva, as it's called, were violated. So that he would be allowed to grow his hair as he wanted. The court's judgment in this case, the court said, the magistrate judge properly found that the Diaz versus Collins case was where this site, and also Longoria versus Frederick, foreclosed Thunder Horse claims against the hairlaying policy. In both cases, the plaintiff, like Thunder Horse, and also like Andy Partridge in our case, were prisoners who, for religious reasons, sought permission not to cut their hair. In the Diaz case, he followed the religious practice of the Aztecas, and in the Longoria case, the inmate practiced the Mexican or Native American religion. In all of these cases, the court found that the policy substantially burdened a religious exercise. However, it was the least restrictive means to serve a compelling governmental interest, which was the prison security. The big issues that prisoners may hide weapons and other contrabands in their hair can only be approached by applying the least restrictive means for the religious inmate request. Also, I'd like to add that requiring short hair makes it more difficult for an escaped prisoner to alter his appearance from the photograph that the facility takes periodically of each inmate. Another case I would like to bring up on the same issue is the Cooperman versus Wren judgment of the District Court, August 27, 2010. A case in which Albert Cooperman is an inmate in the New Hampshire State Prison. He brought suit to challenge the prison regulations that prohibits an inmate from growing facial hair longer than a quarter of an inch. As an Orthodox Jew, Cooperman claims that the regulations violate his rights under the Free Exercise Clause of the First Amendment to the United States Constitution, the Equal Protection Clause of the 14th Amendment, and the Religious Land Use and Institutionalized Persons Act. Before the court is defending motion for summary judgment, who can object? Where they deem a compelling governmental interest. A compelling governmental interest is one that gives the government sufficient reason for the uniform application of a particular program by offering evidence that granting the request religious accommodation would seriously compromise its ability to administer the program, as stated by Gonzalez versus Olsen-Trino, United States Supreme. I'm just citing this is another case that cites the. I finished with when the. The question you're asking me is on the ruling of the case. The different case. August 27, 2010. The question is, the holding, it was different issues, and I would like to present separately each issue how the court rules upon it.
Well, as far as part of their issues.
They deemed it was a compelling governmental interest due to prison security, and saying that their reasoning was that allowing more than a quarter of an inch hair or beard to an inmate gives the inmate chance to use contraband of weapons or other illegal, something or whatever. Under the Equal Protection Clause, which states that no state shall deny to any person within its jurisdiction the equal protection of the law. This constitutional right prevents the correction facility from applying laws or regulations differently to an individual. At the trial level, any party's religious demands were outweighed by the court due to a compelling governmental interest. Differently, facilities facilities are allowed to adjust their policies and regulations to their inmates, for the type of facility they are and the level of facility that it is. But when you apply it differently, is wherein you violate the Equal Protection Clause of the 14th Amendment. Also, I'd like to approach the inmate's claim of not bathing for a whole month. Where I believe the true object of bathing is not only to remove the very complex exterior surface of the body, but to accelerate the action of the pores and thus enable the interior organs to properly and effectively perform their functional process. By not permitting this, a person can be putting down their guard in a combat against diseases and against respiratory diseases and some different kinds of flus. Being the swine,
we're doing this for his own good, health.
Yes. Also his health and the rest of the inmates and employees of the correctional facility health. So I was saying, being the swine flu is one of the most dangerous. The state of New York has recently encountered serious issues with the swine flu. The New York Times publicized the security measures that were being taken by the state to prevent this flu from spreading in the article called "Flu Leads Rikers to Cancel Visit from Some Inmates." This article was needed by Major Michael Brewer and his departing Health Commissioner, Dr. Thomas Frieden, on May 17, 2009. This article shows the limitations applied to inmates to prevent the spreading of the flu and the negative influence that the lack of hygiene on this situation.
The justice has decided to take judicial notice of the health issue that we want to.
All right, so that will be it. Thank you very much.
I would like to say that Clinton Correctional Facility do provide inmates with reasonable religious dietary needs, but some inmates do have to alter their diet. Providing special meals to downtown inmates costs more than providing 1 or 2 standard meals per inmate. The Swanton Correctional Facility has to consider the budget they have as well as security, safety, and staff. Because there are a lot of different religions in the facility, we can only provide certain religious diets. Providing each religious inmate with a different diet can delay the feeding process. The food is not stored properly, or if the food accumulates, they might get unsafe environments with rodent infestation, causing inmates to become sick.
Why do you not store food properly?
Well, when there's accumulation of food, they might not have enough storage to put the food in.
When you say mine, they won't.
They probably figured that out. I mean, it just
Don't know the time. So some of you may do, he's not the only one
no. As least restricted means, the Swinton Correctional Facility do offer certain raw foods, such as banana, oranges, and apples. The budget, security, safety of the Swanton Correctional Facility is considered a compelling government interest. And I would like to, in Africa versus the Commonwealth of Pennsylvania, Frank Africa is a naturalist minister who is also president of Commonwealth of Pennsylvania Official Court Judgment, holding that the state government is not required under the religious clause of First Amendment to provide them with a special diet consisting of raw food. A witness at the hearing in the district court, Julius T. Superintendent Bradford prison testified that his institute unwillingly feed the dietary needs of Frank Africa. He expressed concern about the possibility of a proliferation of other groups servicing in and out of prison to request state diet, and one that if the court were to grant Africa's desired release, the organization would attract new supervisors. Julius contended that the prison cafeteria only made available to inmates a number of raw foods, such as bananas, apples, and oranges, as I have stated. There were particular reasons he explained why Bradford could not be any more accommodating.
That was, they would say apple, oranges, and bananas are sufficient diet for someone who eats raw meat.
I mean, like, we could only start certain, I would like, well,
Go ahead, I mean, you don't have to say
well, it's like, okay. Some of the food that was asked by Africa, particularly the potato, rice, corn, and berries, is not kept under strict security, will probably be stolen and used for other purposes, such as to make homemade food. Accumulation of raw food might lead to bloating, and furnishing special diet delay prison feeding process.
When you say not under security, you're talking about the other person working in the kitchen?
Yes.
contraband, or other prohibited items on inmates. Also, it avoids being mistaken for gang affiliations, which can lead to fights and riots. It also ensures public safety because it enhances the information of inmates who attempted to escape or who had escaped. It also allows prison officers to enable them to differentiate between inmates and visitors. Mohammed versus Death, 2010 West Law, 28, 42, 75, 6.
We take judicial notice of a prison.
that her intent was to bring upon facts where people can research about Moot and find out any history on him or any rumors that's going around. And that is a pure sign of that she believed that these things, that she knew already that these things were not true. No, she didn't. So, the elements of intentional emotional distress were met, and how these portions stood outside of a prison parking lot every day. Not as much as the part of picking, but the website. The website shows. No, I'm not saying that it's okay, but what I'm saying is, well, other than that, my actions, including the picture, the photos, the literature, and the website that she created, was all done under a forethought with malice.
Would you differentiate in certain terms as to whether your statements of opinion and fact, in particular, on someone as a racist fact? Yes.
And the fact that we see that this is not a mere opinion, it's also a suggestion as to convince other people of her thought of the issue. And in this case, she posted, the way she stated her opinion, as she calls it, was not, cannot be considered just an opinion, a simple opinion. I see that this is a more higher standard than just an opinion.
But what I'm trying to differentiate is talking in terms of someone's beliefs or political views, or one thing in terms of fascist and racist as it is an opinion or fact, as opposed to rapist, pornographer, and deviant. Do you differentiate between which ones would be opinion and which ones would be fact? Or are they all statements of fact or statements of opinion?
This is factual information we're referring to. A person cannot just give an opinion about something that's pure fact. It's reckless disregard of the truth to say something as a pornographer or a rapist without investigating the real thing, if it's true or not. Just to add a little bit of that to back it up with a case called Bianco versus Sigma Alpha Ellipsis Fraternity, April 5th, 2007. What happened in this case was that Mr. David Bianco brought action against Sigma Alpha Epsilon fraternity for intentional infliction of emotional distress, alleging that the fraternity published information concerning director's past legal difficulties after the director began investigating on their fraternity. In this case, the court held that to prove the intentional infliction of emotional distress, they had to prove actual matters. So in our case, I would like to say for our client that, and for the other party, that her actions are there's a clear thing of what actual matters is. Like she approached, like the way she spoke about this issue with like the question that Judge left.
can now verify this information. In other words, if this would be true, there would be legal proceedings towards, you know, the kind of criminal statement that you made of the client.
Invasion of privacy,
Okay, I was afraid we were going to do that.
in the case of invasion of privacy, a person has the right to sue if the individual's privacy was invaded, not by his family or a friend. A right to sue for invasion of privacy belongs to the individual whose privacy was invaded. Sorry. The plaintiff must be able to show that highly private information which the public has no legitimate interest has been communicated to the public at large. In Star Telegram Inc. versus Doe, 915 SWD 471, Jane Doe was the victim of sexual assault. Sued the Star Telegram, holding the newspaper liable for disclosing private text about the victim of sexual assault, which makes the victim identifiable by her grievances. The Supreme Court held that under the specific facts presented, the information disclosed by the newspaper concerned matter of legitimate public concern. But unlike Star Telegram Inc. versus Doe, the literature was the owner of Mullins' home, family, and automobile, and his personal history that was publicized by Holly Partridge, but not a legitimate public concern. Our client is not a public figure, but even if he was a public figure, our client was working as the Commissioner of Corrections. To allow Holly Partridge to hand out these information is like giving dangerous prisoners and their family or friends information about the person in control of the place, and the right for people to go and harass him and his family. A prisoner,
I'm saying the family becomes known by their association.
well, their family became known by people that might know them, even if it's like they're a prisoner in there that's in related to gangs. You know, there's a lot of reasons, especially since he's a commissioner and he makes a lot of these judgments. There are inmates in there that really dislike, or you can even say hate him, and would actually use harm to
You say on his own behalf or on behalf of his family?
put it on behalf of them.
I mean, I'm just saying, that was
to worry about is rice being snuck out of the kitchen and, you know, becoming an assault weapon when they're using knives and whatever other options, whatever tools to cook and chop the food up. Okay, also, in regards to the fact that the website was, among other things, suggesting, I wasn't sure that suggesting something had become such a crime as opposed to making it a fact. She did not say that it was a general fact that he is, I know he is, and he is definitely a rapist, he is definitely a child molester. She suggested it. I guess you consider that a form of figurative expression of discussion. The way she chose to speak is how I'm seeing it. I mean, it doesn't say it's a fact either. It's not a fact pattern. So not only is it not pointing in an opinion, it's not pointing in a fact either. And then also, when we address that, they can only store certain foods. So wouldn't that be in regards to showing a bias to one side of foods from another? If you can store certain foods for one and not the other, should it be just a general, if you can't store food, then you can't store certain things, period? Being able to say that I can store foods for this group of people, like, for example, give kosher, if you people who have kosher food, seeing as to how you can store food for them because they're kosher, and budget-wise, she said, something about the budget being able to hold enough money to keep things refrigerated. I don't see how that is even fair. That kind of goes to exactly what we're saying. It's not fair in any sense. If a budget can decide that, well, since you're kosher, we can hold your kosher food, but we can't hold your natural food, I don't see as to how that is fair. And that was one of the arguments that she said. I just wanted to address that. Yes, we do. Thank you. That's it. Sorry. Thank you.
Today, many issues were discussed, and the court has heard our arguments on behalf of Andy and Holly Partridge. Swinton County Correctional Facility wants the court to believe that they were right when they maliciously forced Andy Partridge to cut all facial hair, alter his diet significantly, not wear his hemp clothing, and force him to bathe once a week. Andy Partridge would like nothing more than to be allowed the constitutional freedom to practice his religion in prison that is guaranteed under the First Amendment of the United States Constitution and the Religious Land and Institutionalized Persons Act. By allowing Clinton Correctional Facility to continue to force Andy Partridge to undergo harsh treatment would be unconstitutional. They are forcing Andy Partridge to become someone he is not by taking away his expression and punishing him to a point where not only is his freedom gone, but his will and spirit as well. Colin Mulvey would like the court to rule in favor that his privacy was violated intentionally. Intentionally emotional distress was inflicted on him, and the court should take away Holly Partridge's First Amendment rights by barring her from standing on public property and granting an injunction that her website be taken down. Holly Partridge's speech is in fact protected by the First Amendment, and nothing was done wrong by a simple act of stating her opinion about how she felt about Colin Mulvey. If the court rules in Colin Mulvey's favor, the court will become a slippery slope of lawsuits, and the First Amendment will become nothing more than ink on paper. It is the court's right to protect the constitutional freedoms of the citizens of the United States of America and not to entertain frivolous judgments.
You might notice that you're going to have to be the question you didn't have rebuttal to the...
All right.
Wait. They have rebuttal to your statement that you argued last. So
being civilized living within the facility. If my clients are guilty of anything else, it is simply doing their job. If that is unconstitutional and violates the First Amendment, what is the job for in the first place? If everyone was allowed to do as they please and be able to tax anyone with their speech when they please, then we would not have a need to have the law to protect the citizens from such acts. On behalf of the issue with Swiftly Correctional Facility violating his First Amendment rights, as you can conclude from the arguments for today by my Swiftly State Correctional Facility had no intention of restrict his right to freely express himself religiously. Beyond the point of upholding the procedure and trying to maintain a civilized order for the civilian workers and prisoners. On behalf of Commissioner Hogan, what wrong has he committed other than doing his job to be viciously attacked by the country, to have his privacy invaded, his family's privacy invaded, his personal life put out in public eye? If the court allows Ms. Partridge not to take responsibility for her actions, what example are we setting for the rest of the state citizens who have a constitutional right to right to privacy? Furthermore, what precedent are we setting for those who wake up one day and want to detain any person for just wanting to do so? If that be the case, what are our constitutional rights protecting, if not us? So in conclusion, I ask that you take everything you've heard today into careful consideration. We should really protect those who break the law and try to cover their actions with the First Amendment, or those who try to hold it. I see no tangible evidence that concludes that certain state corrections facility, Commissioner Moot, were acting in any way out of accordance with their prison procedure. Moreover, no concrete reason for Ms. Partridge to defend Mr. Collins' reputation and right to privacy the way she did. Therefore, Smithton State Correctional Facility and Commissioner Moot did not violate the Agriculture's First Amendment right, but sadly, no Mr. Moot's rights were violated in the process. I think that the court upholds the Constitution.
Thank you, folks. All right, judges, so we ready? We'll be back shortly with the decision. It may take a minute or two. It's not going to be easy for the judges. I would ask that everyone's patient. We'll give the decision when we come back, and then we'll leave. Okay? Give us a few minutes. Thank you. Okay.